ESG deficiency on employee compensation. When it comes to ESG and employee compensation, ESG, or environmental, social, and governance policies and programs, aspire for some very altruistic objectives while undercutting numerous performance-based metrics, yet more significantly, distracting employees from broader and more comprehensive aspects of their employment, which is causing them significant harm. Nevertheless, because special interests are being allowed to shape the conversation around ESG, they are being driven to focus on areas that allow employers and corporate power players to dictate the conversation, and therefore frame the entirety of ESG, especially as it relates to employee compensation. This may appear to be a very radical assertion. However, with extensive non-discrimination and human rights laws now being heavily enforced, effectuating discriminatory pay practices is very difficult, especially where most employers structure pay without consideration of any gender, ethnicity, or orientation characteristic. That is not to say that there are isolated instances where certain employers and superiors show favoritism or act on their biases. However, those instances are exceedingly rare, while allowing, quote, compliant employers, end quote, to proclaim their stellar record on employee compensation for ESG purposes. Yet such a limited criteria for assessing the adequacy of employee compensation in relation to a company's ESG score is only possible because it was built around probably the worst employment rights and protections country in the industrialized world, the United States of America. Out of all the OECD countries, the United States continues to lack comparable employee compensation legislation to that of its OECD compatriots, instead being reliant upon the individual employer's contractual arrangements with their employees, such that those aspects are not afforded any true weight, which American employers are entirely comfortable with avoiding. However, in other OECD countries, including Canada, there is substantive legislation around employee compensation, which is far more complex than most people understand. And that legislation not only varies between countries, but can also vary substantively within a country, as exemplified by the Canadian situation, with each province having its own employment standards legislation, together with the Canada Labour Code applying to certain employees across the country who are in federally designated employment. And when they are applied to the particular employment arrangements that each employer has, the complexities are even further exacerbated. The potential for statutory mistakes are quite significant in these jurisdictions, such that possibility for errors in employee compensation cannot be discounted, especially when one considers the lack of importance placed on employee compensation, with overworked, underpaid, and undertrained payroll staffs employed by most employers, and with professionals not sufficiently engaged in the implementation and review of employee compensation. The prospect for adverse impact to employees is considerable, and as such, a far more extensive and detailed review of employee compensation deserves serious consideration in a comprehensive ESG review. What the specifics of this broader employee compensation review entails will be dictated in large part by the jurisdiction's legislation related to employee compensation and how it operates in the context of the employer's contractual arrangements. If these aspects are not brought into the assessment of an employer's ESG rating, then employers will be avoiding a very significant aspect of what ESG really should be, such that it does a major disservice to the entire purpose of ESG, as it enables employers to dictate the assessment of employee compensation to the severe detriment of employees. Thank you.